You won't believe it, my other computer is still actually on 0% updated after 2 hours. I don't know what to do. So I had to use a children's PC and set it up quickly. Tobias, are you with us?
Yes, I'm here. Good morning.
Great. Good morning, Tobias. Colleagues, I do apologize for the bit of a late start. I see we have 66 participants, and I'm sure more of us will join as we go along. And there's also some special guests in attendance, which I'll get to now. But first of all, welcome to all of you as librarians in the series of, in the first of a series of planned presentations on this very critical and much debated topic, being copyright. I'm of the opinion that as librarians, we assume knowledge of copyright and related legislation, as this is obviously one of the legal frameworks that shape our roles. However, I also think that often we might be one of the transgressors of these said laws, legally not complying, but perhaps morally correct. And that's something we can discuss going forward. And part of this digitization and South African copyright law series would also be to stimulate debate pertaining to the copyright amendment bill that we would very much like to be submitted and signed as soon as possible. So this series of discussions is implemented to firstly provide the basic legal understanding of copyright, and secondly to ensure collaboration with entities in the open knowledge society. And hence also as special guest today, we have in attendance Douglas Scott from the Wikimedia South Africa chapter, and also Paul West from the Creative Commons chapter as special guests. We will also be talking to librarians hopefully in the future very soon. I know that we are busy planning one session already on Creative Commons. Before I can continue, I just want to catch my breath. I'm sort of out of breath because of stressing about this machine not getting on. But yes, so I'm going to allow Tobias and Tobias Schoenwetter, I think you're a well-known entity amongst librarians in South Africa. And yourself and Denise Nicholson, who I believe is also in attendance, very, very prominent in the area of copyright, and I think we definitely need to listen to you. Tobias, I don't have your blurb in front of me because that's on the other computer now, which I can't get started. But I know that you are heading the Intellectual Property Rights Office or something at UCT, but maybe you can just sort of introduce yourself. And I'm really sorry for this, but I just don't have the information in front of me. But I'm going to hand over to Tobias now. Thank you.
All right. Good morning, Lena, and good morning, colleagues. Thanks for the introduction. I've started my video, and I hope that people can see me now. Perhaps someone can just put this into the chat, like a thumbs up or something. Great. Yes, we can. Good. I see a lot of familiar names. Yeah, I'm very pleased to see the high turnout for this meeting today. I want to start off by saying thank you to the LIASA team for organizing this. I think it is an important topic, certainly under the circumstances that we are operating under at the moment. Greetings from what really is a pretty chilly Cape Town, including my office. I think we all have kind of gotten used to these. This, by the way, is not really my office. This is the background. So I think we have all kind of gotten used to these kind of webinars and presentations. It's great to be able to connect in this way with one another, but I have to admit it's still not my my favorite way of engaging with colleagues like those here on this call, because it just lacks that type of interactivity that normally comes with a face-to-face seminar. So I really do encourage you very strongly to make use of the chat functionality. It makes it so much more fun for myself also to see if there's questions, comments, and so forth happening. I was pleased to see that people had already started to welcome one another in the chat. So please keep on doing this. I will try to keep track of what's happening in the chat. It's always a little bit difficult as a presenter to do that. I said earlier when we had a bit of a test call, I'm trying to operate 3 screens here actually to do these kind of seminars and also the engagement with my students, but still it is a little bit tricky to just not miss like important questions. So I would probably like to ask also those from Liasa, Vanan, perhaps if you can from the computer that you are now using, to monitor the chat a little bit and to really interrupt me and alert me to questions that need addressing while I go along. So let's make do with what we have. I've done a few of these, and it turned out to be usually quite nice. I will share my screen in a second with my presentation, and I want to just warn you before I start though that I have a very strong-willed 1.5-year-old in the house, and she loves Zoom calls. She knows that I'm doing these, and she normally uses these moments to knock on the door to make some noise. I have started to not really hear that anymore, but you will hear that, so I apologize for that from the outset. Typically, people that participate in my webinars or lectures find that actually quite funny, but I'm sure you will hear at some point. Great. Looking whether there are any questions so far. Obviously, this is just a little bit of housekeeping right from the outset. Otherwise, if there are no questions right now, I would just dive directly into the topic. There's a lot to talk about, and we don't have infinite time available.
No questions yet, Tobias.
I can see, but there is some discussions there. Okay, so this normally, this kind of change from this presentation mode to the PowerPoint takes a little bit of fiddling on my side. So perhaps you can just confirm with me that you can see my screen right now. Someone in the chat again, you should see the not yet started PowerPoint presentation. Is that so? Yes. Oh, I don't see an answer there. Yes, okay, great. And then I will just start the presentation here quickly. Wonderful. Move the chat to this side. So I can see this, and everybody, all the participants to this side as well. And then last question, you can now see full screen the first slide of the presentation, correct? Yes, we can. Fantastic. Thank you, Niklas. How are you doing? I see there's quite a few UCT people here. I'm quite glad about that. So, digitization and the South African copyright law is the topic of the day today. I thought I'm going to start off with some copyright basics, even though I'm fully aware that kind of carries the risk of telling you some of the things that you already know very well. But it is a big crowd, and knowledge levels might differ. And I really do think that knowing at least the very basics of copyright law are quite important to understand some of the issues in the context of digitization that we need to talk about them afterwards. So bear with me if this is all old news for you. I'm sure there is some among us that will find that first part of the presentation useful as well. So to really start off on a very high level, perhaps, is that when we talk about copyright law, we're talking about one pillar of intellectual property protection. There's several other ones, 3 of those, or 2 of the other ones you can see here already. So there's not only copyright, but there's also patent and trademark law. There is protection of indigenous knowledge frameworks. There is design protection systems, trade secrets, quite a few other things, but I just want you to understand that copyright is situated within this kind of bunch of IP rights that are all falling under the umbrella of intellectual property. I'm not going to talk about any of the other forms of intellectual property today, really just copyright. And I thought I'm going to start off with what could be seen as a pretty basic and general kind of definition of copyright really is all about. And this is the same the world over, that copyright laws operate in the way that the moment a creative work is being created, the creator gets a time-limited monopoly that allows him or her to decide if and how others can use this work. So maybe it requires a second reading or so, but I think this in a nutshell really nicely summarizes what copyright is all about. If you create something and you own the material, we're going to come to the issue of ownership a little bit later, then it's really up to you to decide whether you want to use the work and how, or whether you want to allow others to use the work. Also linked to the previous slide, perhaps, it's quite important to also understand that there is no such thing as an international copyright. Sometimes you see that terminology floating around. It means something different, but there is no kind of global copyright law that applies in all countries. Instead, the scope of copyright protection in a certain country like South Africa really depends on the South African copyright law, or in Zimbabwe, the Zimbabwean copyright law, or in Germany, with my home country, as you can no doubt hear, the German copyright law. But what has happened over the last decades also is that there has been some level of harmonization. So if you look into another country's copyright law, not everything will completely look alien to you, because there is some harmonization that has happened over the years, because of international treaties and other instruments like the TRIPS agreement. So this is what people sometimes refer to international copyright law, but these are not applicable directly in the countries. These are just instruments that prescribe minimum standards for protection of the various forms of intellectual property, including copyright law. So if you hear about the Berne Convention, TRIPS, the WIPO Internet treaties, and so forth, this is all interesting for South Africa, especially insofar as South Africa has joined these treaties, but they do not apply directly in South Africa. It's really for South Africa then to adjust its domestic laws to adhere to these international treaties. So quite an important, very general kind of remark from the outset. And then if you acknowledge that copyright laws are domestic, then I guess that kind of is the first highlight of one of the key problems is that we are facing, also in the context of my presentation here today. So this is, I guess, more or less a photo of how computers looked like when the current South African copyright law was kind of being discussed and finalized. So our current legislative framework is more or less, there have been slight modifications since, but more or less it's still a piece of legislation from the late 1970s. 1978, I'm sure, I haven't looked now, but I'm sure that there's many amongst us here that weren't even born back then, but even those that were will still remember that circumstances then were very different to what are they now in terms of what the capabilities of technologies, digital technologies and so forth were. So now trying to find answers in that 1970 piece of legislation to the current questions raised by the modern digital technologies really is a tough ask. And every day, almost, I'm getting questions that I think I should be able to easily answer, and it's actually not as easy as one would think. So just a good example, yesterday, or the day before yesterday, I was dealing with a question from a colleague here at UCT, and I was asked whether one can use a screenshot of the Take-A-Lot website in an openly accessible textbook. Now, this doesn't sound like rocket science from a copyright perspective. It really took me some thinking and some digging as to what the answer to that could really be, and trying to apply 1970s law and language in the law to what has now been a common practice. And the answer is really not clear. I mean, apart from the fact that you could ask for permission, which is always an option, and that is a clear and straightforward, but perhaps a bit of a tedious and potentially costly way of doing these kind of things. The copyright law doesn't tell us much. So these are some of the challenges that we are facing. This is also one of the reasons why some of us are quite excited about the fact that the South African lawmaker is in the process of at least proposing new legislation in the field. But I will return to this a little bit later. So for now, what we're dealing with is 1970 kind of legislation. And just to bring to your attention a couple of things that are different now to what they were in the 1970s. So what is so different now in digital as far as copyright is concerned. This is an open list. I should have probably added a couple of dots at the bottom just to indicate that this is just what I came up with in a very short and limited period of time. But what we can do now, what we were as at least as private citizens not able decades ago, is that we can make unlimited number of copies virtually instantaneously without the loss of quality. I think this is one of the big changes. I think those amongst you that still know photocopy machines, you will know that perhaps from the rights holder's perspective, making unlimited number of copies and copies and copies and then copies of copies of copies and so forth wasn't as much of a concern back in the days, because there is a deteriorating quality of these copies. The more copies you make, the least you can actually see. And at some point, you will need to revert back to the original and buy a new textbook or something, because you can hardly see anything on the umpteenth copy, I guess. And this has changed, because the millionth copy of a copy in the digital space is just as good as the first one. And I think this is one of the concerns and challenges that we are facing. The works are much more easily to modify, to tamper with. One could also say easy to distribute. You click a mouse button and not even a second later, it arrives in another corner of the world with a different kind of protection regime. As I who owns the copyright in the photo. What you may have as an individual being depicted in the photograph is privacy rights that may prevent the photographer to widely distribute that photo. Also, the more famous the person is that you have taken a photo of, the least privacy, the lesser the privacy right become. But this is actually a different area of law. So it's moving away completely from the question of who owns copyright in the photo, which will typically be the photographer, and like the personality rights, like privacy rights that one has in one's own kind of appearance, which may collide, but which actually have not a lot to do with the question of copyright. I hope I kind of answered that question on the go here sufficiently. Returning then to the set of exclusive rights, you've seen them now. So these are the rights only the rights holder has the right to do, or the right to authorize others to do in relation, again, as a reminder, to these types of work. So I don't want to speak much faster, but I can see I should, because time is progressing rapidly here. But we're close to finishing up that Copyright 101 session here. I think it's important also for people to know that copyright differs quite substantially from other types of IP protection in that, and that is really a kicker, and that's why I highlighted here, certainly for my students often, you don't have to do anything to get copyright protection. Copyright protection, once these three requirements that you see here are fulfilled, comes into being automatically. In fact, actually, regardless of whether you want it or not, whether you know about that or not. Registration is not necessary. There is no form to be filled in. There is no fee to be paid. As long as what you create is original, is somewhat reduced to material form, which has now also been interpreted in the digital space as something on the internet, because there will be somewhere a server where the actual file needs to sit. Was a question for a while, but really during the early days of the internet. And one has to be a qualified person, which in South Africa means that you have to be domiciled in South Africa that from the outset, but at the same time, this has now been extended to also nationals of other countries that South Africa is in treaty obligations with. And this is why I've put this in brackets, because it is really no longer a real requirement, because that is really most other nationals other countries. So really, the two main criteria for copyright protection are that the word is original, which in South Africa we still interpret in the way that someone needs to have exerted some effort into creating something, sort of the Brown doctrine we call this. As long as you have done that and you have reduced it to material form, copyright arises. That also means, perhaps coming back to that question about ownership, is that interestingly enough, if I was now in a classroom setting and I would orally tell my students something, and my students would perhaps not verbatim, but kind of write down what I'm saying, applying their mind a little bit to put it into better English, and reduce it to writing, then it would actually be the student who owns the copyright and not me, and what is my idea, what is my what I said in class. It's mind-blowing to some extent, and I know quite a few people that don't like it, but this is what copyright really is all about. Only the person who reduces something to material form really is the rights holder. Coming back to the questions here, what about trademarks? Where the two children sit at the laptop and Apple trademark clearly shows. So trademarks, I mean, again, trademarks is a different type of intellectual property. Different protection regimes. So in parallel to patent protection and copyright protection, there is also trademark protection. These forms of IP can certainly be overlapping. So it doesn't mean that just because something is trademarked, it cannot be copyrighted, and vice versa. I guess from a practitioner point of view, often if you develop an IP strategy, you would actually try to get as many different forms of intellectual property for really the same thing as possible. But you're absolutely right. The photo there contains a trademark. It's also probably copyrightable and copyrighted. If we now want to know as to whether we can use it or not, we would have to consult effectively two pieces of legislation. The Copyright Act, we talk about that, how you can use third-party material further down the line today, and the Trademark Act as well, to see whether you're not infringing someone's trademark. I will not talk about this today. It is less likely though, because one of the requirements for trademark infringement is that you use someone else's trademark in the course of trade, which I guess it would be a bit of a stretch to apply that kind of terminology in the education sector. But it could be.
Tobias?
Yes.
Apologies for interruption, but
it may, because then I can drink a little.
Oh, good. What about, I think it's called an amendment, it would be called panorama, where trademarks or things will be in a photo. So what is currently the right, and what, if I'm correct, the amendment will allow for, I think it's called panorama, which then means there might be trademarks in the back that's legal.
Yes, so it's more about copyrighted works in the background, not only trademarked things. They may also be trademarked, but the question about the panorama right is really as to whether I can depict in my photo things that are actually owned as far as copyright is concerned by others. So, for example, a statue, or even like a certain kind of front of a house, or a shop front or something. These in it by itself may enjoy copyright protection, and by including them in your photo, there is a question as to whether you actually infringe the copyright of the owners of these kind of copyrights. Our current Copyright Act is not very permissive in terms of whether or not this is allowed. In fact, it is typically a copyright infringement. And it is one of the kind of reasons for the copyright bill to include provisions that would going forward and allow these kind of uses. I think if we can perhaps we could return to this in the Q&A session a little bit later, because I mean I'm so tempted to actually hand over the microphone to Douglas Scott, because you mentioned him earlier, because he was one of the main pusher and drivers of this to be included in the copyright amendment bill. Because obviously from a Wikipedia point of view, this is quite a crucial kind of bottleneck in terms of being able to use photographs with potentially copyrighted material on a platform like Wikipedia. So it would be great from that platform's perspective to be able to not infringe people's copyrights by having copyrighted material in the background of one's photograph. But currently, it's not allowed. But I want to steer us away from muddling together the trademark and the copyright question here. It's two distinct areas of law; they intersect. But I think one also, in terms of actually answering these questions, one can really only answer them proper if you stick to the relevant areas of law and answer the question depending on the different laws as they apply. That is okay. So then there was a comment here from Niklas. While working at a newspaper, we were always told that we wouldn't have to ask people in pictures for their names and consent whether there were more than 4 people depicted in the photos with track. Okay, so it's interesting that I guess it's I don't really know where that comes from. It doesn't come from. So again, it is not a copyright question. It is a privacy question, and there might be some case law on there that would say if there's a group with more than 4, then the individual is not identifiable in a way that infringes upon someone's privacy right. I'm not aware of such case law. Privacy is generally, from a legislative point of view, not legislated very well. Although now with Poppy, this is starting to change, and I wonder whether I'm pretty skeptical as to whether newspapers would continue to say that in light of what Poppy now prescribes. So it's an interesting, I guess, practical kind of direction that, as far as I know, I'm not sure where this is rooted. But again, we're kind of venturing out of the copyright legislative frame into what really is the privacy space. Okay, let me move on here. Keep on with these questions. They are important. Basic message here: as long as something that you create is original and in material form, it is copyrighted. To drive that message stronger home, I guess, is if there is anyone amongst us here that actually takes notes, in spite of recording and everything, of what I'm talking about, but actually takes his or her own notes. These notes, under South African copyright law, are now copyright protected. And as you will see on one of the next slides, for a very long time. Okay. No registration necessary. Idea itself is not protected. So once something is original and reduced to material form, what we have is a default and automatic all rights reserved situation. And that means that permission really is henceforth required for most users of these works, regardless of whether or not it is easy to locate or contact the copyright owner. I added this little bit here at the bottom because there was quite a few questions beforehand about what we refer to as orphan works. Under our law, often the employer and not the employee owns the copyright in the works that they create, including in, sorry, I'm just getting a call here that I want to end quickly. In employer-employee relationships, it's often the employer. So if you work for a university and you write something in a journal or something, before you potentially sign over your copyright to the journal, it would typically not be you as the actual author, but it would be your employing institution that would own the copyright under our law. But this may obviously be altered and changed through contracts, funding contracts also. And it often, in fact, is or IP policies, institutional policies that certainly we have at the University of Cape Town, which makes things a little bit more complex, but I think for the right reasons, and that some of the works that we create are actually owned by us, whereas other works that we create are owned by the university. Has to do with the fact that they want to ensure that they can continue teaching courses that we created, but at the same time, the university that I'm employed by does not claim necessarily the ownership in the journal publications that I write. Okay, moving on here from this. Again, here for the audience for today, quite important because there is that misperception perhaps. Just because you own the physical copy of something and you have that in your collection as a curator or something, does not mean that you own the copyright in this. There is a distinction between physical ownership. You can do with that book more or less what you want to do. Don't copy it, but you can give it to people at your and lend it to people and whatever you want to do. But the moment you actually start then reproducing it and disseminating it and so forth, you're touching on the IP rights in the material contained in that physical copy, and that is a different layer of protection. And you not be necessarily the owner of that material. If there's long contributions here that I'm trying to go through here. One argued that, okay, that is from Sanjin. Hi, also UCT, related to Vainan's question above, if we have an archive of theater rehearsal warming up. That's a long question. Okay, let's park this for now, if that is okay. I'm gonna come back to that in a second. I will not forget it when I make a note here. But we do have a relatively long Q&A session, which I think might be a good place to answer this question. I want to get through this basics because we haven't really touched that much on the actual digital kind of implications. Duration of copyright. This is dependent on the nature of the work. So in other words, as to whether it's a literary work or musical work, artistic work, whether it's a computer program, and all the other kind of categories that you saw earlier. But as a rule of thumb, at least for literary works, musical works, and artistic works, not photos, which normally are a subcategory of artistic works, but they have a different duration. But generally, artistic works and literary works and musical works are protected for 50 years, I shouldn't say 50 years after the death of the author, because it's slightly different. It's 50 years from the end of the year in which the author dies. So in other words, if one dies at the 1st of January, it's still that entire year, and then 50 years. This is slightly longer than what we are required to do under international instruments, because international instruments do say 50 years after the death of the author, but it is still pretty close. Other countries and regions have gone even beyond that, in that they protect now for 70 years after the death of the author. I guess the European Union countries and the US are good examples for this ever-increasing duration of copyright law. And this is a long time. I mean, if someone creates something, say, at age 20, lives until age 80, that's 60 years for which the work is protected, plus another 50 years. So we are in excess of 100 years here, very quickly. And it is during that time that one can only make very limited use of these kind of works from a public perspective. Okay, then. Okay, people are saying hi to each other. This is good. And copyright infringement, what then is infringement? It's really the opposite of what the rights holder can do. So if, here's the actual wording from section 23 of the Copyright Act, copyright shall be infringed by any person not being the owner of copyright who without the license of such owner, without permission of such owner, could also say, does or causes any other person to do in South Africa any act which only the owner has the exclusive right to do or to authorize. So I changed it slightly, and I tried to also, by the way that I read it, to make it digestible, but I think it's quite straightforward. Those who are not owners of the copyright and do not have permission from the copyright owner, who do things that otherwise only the retain permission to others can be limited in many ways, time limited, geographically limited, limited in terms of what they can do and what they cannot do. So it's quite flexible. You give these permissions to others to make use of the work. So those two categories, licensing and assignment. Okay, sure. That was the first part, 101. Of course, get permission. A license from the rights owner, that can be a permission, kind of a specific permission given by the rights holder upon request, or it could be an Commons license where rights holder says something upfront in terms of what they allow and what they don't allow in terms of the use of the works. Or you could, which I like, but which is sometimes might be a little bit risky, because that while I'm talking here mostly about these so-called economic rights, the reproduction right, adaptation right, distribution right, and so forth, there is a parallel framework of rights in the copyright space, which is called moral rights. Not well addressed in the Copyright Act, but we know that they exist. But one of the things that our Copyright Act currently, for example, doesn't say is for how long these moral rights do exist. So moral rights are, we usually refer to as the right of being identified as the author and being able to object to derogatory kind of treatment of your works. And our Copyright Act is silent on the duration of these rights. So it's actually not clear as to whether they die with the author, which is one opinion, whether they kind of end with the economic rights, which would then be okay in this context of the public domain, because then economic and moral rights would kind of end at the same time. But there is some people that actually say, well, actually moral rights never end. And if this is so, then they may actually survive the end of these economic rights. Don't want to dwell more about this. It's a little bit complex, but I just wanted to alert you to that. Public domain and further, again, the point that I want to make here is just because something is online or on social media, which we as normal human beings typically refer to as the public domain, or it's written on a wall or something, that does not mean public domain in the legal sense or in the copyright sense. Public domain in the legal sense really is just not copyrighted. So you cannot just take stuff because it's on WhatsApp or because it's on the web or whatever the case may be. For those who are interested in this a little bit more, I wanted to include this, but it's just an observation by some that one of the issues that we are facing with the public domain is that not too long ago, there was actually quite a rich body of public domain works, partially because copyright protection was much shorter and much less works were copyrighted. So for that reason, there was always a very healthy body of public domain works which people could rely on and use without permission. And there was then the thinner layer of copyrighted works. And that seems to have kind of reversed over time because of longer, ever increasing duration of copyright, and because more and more works have been declared copyrightable, the public domain is actually shrinking, and most works seem to be copyrighted these days. So it's an observation that has some public interest concerns attached to that. Do we assume that all works published before 1925 is in the public domain? Let me just do my maths here. So it's 100 years. Or 95 years, I think you're pretty safe, even from an international point of view. 70 was chosen. It is a force to be reckoned with, because this is now the latest 2017 figure, 1.4. If you look at the trajectory of those figures, I think 3 years on, we're probably close to 2 billion works. So it is not something that just a few of us are doing, but it's really a global movement, and it's really the legal backbone for things like open educational resources, for open access. Thanks, Niklas, for joining. Open access, and it's also something that is increasingly required by some of the major global and domestic funders, like the Ford Foundation, Bill and Melinda Gates Foundation. UCT has its own open access policy and so forth, and this requires the use of open licenses, of which Creative Commons is the most well-known and widely used one. So here, Wikipedia, and two examples for in the curation kind of context that are based on Creative Commons licensing, all the content that you find under Wikipedia, as well as the content that you find on the South African Heritage Resource Agency's website. Here is the proof of that. There's a screenshot from the Wikimedia Foundation, and here is the little icon on the SARA website, where you can see that the rights holders declare here that the works that you can find on their platform are licensed under an open license and can be used more freely, not completely freely, but more freely in compliance with the actual license terms of these licenses. More on this in a separate presentation, I would think. And then that is the point that I made earlier. Just because you own a physical version of that of something doesn't mean that you own the copyright in that. Perhaps something to drive home here is that that not a lot of people know that outside of the 6 CC licenses, there's also other tools that Creative Commons has developed over time. In fact, they are doing something in the COVID context, which is called an open COVID pledge, which is quite interesting, but a patent kind of a thing, although they are expanding this into the copyright field. I'm not talking about this today, but I thought for people like yourselves, the fact that there is a public domain mark is actually an important one. And that is because you are considered knowledgeable in the space of of copyright is actually a tool for practitioners like yourself to make the statement to in relation to the works that you are dealing with, that a certain work is in the public domain. Because you know it's so old, copyright has expired, and then others can more easily make use of that because they have the kind of reassurance by this that someone knowledgeable in the field has determined that this work is actually now free of copyright restrictions. I'm not a big fan of that because it's prone for errors and it might give you a false sense of safety and security. But I thought if you're completely if we're talking about works from the 1400s or something, I think then just for the benefit of the public to attach a public domain mark to it to tell the general public that they can freely use these works, I think that is quite useful, but with caution, please. One of the things we have to do is to ensure that public domains marks are inserted into our metadata, yes. And I think Creative Commons tries to also provide some technical language. I guess they provide you with HTML code with their licenses that you can embed in your own if you're using HTML. I'm just not sure whether this is the most up-to-date technical solution that people are looking for, but it's an attempt to address that. And then finally here, the issue of copyright exceptions and limitations. So if you don't deal with public domain works, and if for whatever reasons you cannot or don't want to get permission from the rights holder, the last option really is to say, well, you know what, maybe my use is actually covered by copyright exceptions and limitation. Here's the definition: they curtail the exclusive rights assigned by copyright law to the copyright holder. They do this to promote the public interest and to respect users' legitimate interest in using copyright-protected material in certain circumstances without the permission of the rights holder, along the lines of what I already mentioned earlier. But here, please take this away from today. I hear this so often. Can I use it? Isn't that fair use? In South Africa, we do not have a provision that is called fair use. That is a US doctrine contained in the US copyright law. Super useful, I think, for people in the kind of fields that we are working on, because it essentially says, well, of course, things are copyrighted and you may not use them, but in fact, you may actually use them as long as 4 criteria are considered and met, also in line with what courts over the years, how courts have over the years interpreted the fair use provision in the United States. You look at the purpose of the use, the nature of the use, the amount that is taken, and whether there is actually a detrimental market effect for the copyright owner. And if you come to the conclusion that in light of these factors, the use is fair, then you may use the work without further permission. But we do not yet have this in South Africa. It is part of the proposed kind of copyright amendment bill, but also one of the most controversial one. There has been a big backlash from the rights holder side because they fear that this would allow free users to an extent that would harm their markets. It seems to, like, history or experience from those countries that have these provisions seem to suggest that that might not be the case. But I can see where the resistance is coming from. It's a typical reaction of those that I don't want to say own a market, but that are successfully in a certain market resist change to that market because they would not necessarily benefit from changed circumstances. I think you, from your practitioner point of view, would really have to ask yourself as to whether a provision like this would not be beneficial, and perhaps also make that voice heard. And because that perhaps has not happened. There's some loud resistance, but perhaps not as loud support for provision that I think would make things a little bit easier. I was thinking about that yesterday again, the question as to whether one can use a screenshot from Takealot. I think I would have had an easier answer to this. Would we have had fair use in our law? But we don't have that. We have something else that's called fair dealing. I'm not talking semantics here. It's a different concept. even though it sounds similar, but it's the fair dealing provision is much more narrow, confined to certain purposes only, confined to certain works only. So it's by no means anywhere close to what fair use means. In South Africa, what we have there is fair dealing, as I mentioned. We also have some exceptions for educational purposes, and we also have some exceptions which might be relevant for you, which is for libraries and archives. We have also very permissible quotations, exceptions and limitations. So it's not that we are without exceptions and limitations, but there's a couple of problems with these. The first one is that these exceptions and limitations for the benefits of libraries and archives, which are contained in the copyright regulations of also 1978, are exactly that. They are 1978 kind of regulations, and they don't speak at all or much for like the online kind of environment. And in most cases, they are therefore actually not allowing things that we would think should be allowed in the online space. They are also framed and phrased in quite complex, difficult to understand ways, and I don't know many that really make use of these regulations a lot. Perhaps we can have a discussion on this in the chat if people do, but people usually either don't even know about these kind of regulations, or if they do, they shy away from using them because it's they don't really know what they allow and what they don't allow. Bottom line is that from the outset, these exceptions and limitations should really be key enabler for access to knowledge material, but oftentimes they are not. And that statement I'm making because we have done research on that. This is one of the books that we published there in the corner on that particular issue, access to knowledge material in Africa, the role of copyright law. And one of the findings you see here is that the scope of educational exceptions and exceptions for libraries and archives often unclear, particularly in the digital environment. They speak of things like reasonable portion, no conflict with normal exploitation, not unreasonable prejudice, legitimate interest of rights holder, no direct or indirect commercial advantage, and so forth. And it's really difficult for the person who has actually to deal with the actual copying to assess as to whether they are covered by one of these exceptions or not. And then other than in other countries where people seem to be a little bit more litigative, the approach here in South Africa often then seems to be, well, let's rather shy away from pushing the envelope here. If the option is it could be allowed or not, I rather don't do it, rather than being sued and perhaps get a judgment on whether this use falls within the scope of a certain exception or limitation. Let me wrap up here with my own presentation with a couple of comments with regards to the Copyright Amendment Bill, because it was mentioned earlier. So what you can see here is just like a snapshot from what is called a bill tracker. So you can see that in March 2019, we were at a point where actually Parliament said this bill that we have is good, and we wanted to become a law of this country, and for that they forwarded it, as is usual with legislation, to the President for signature. And it took a year and 3 months on the dot, in fact, for the President, who had clearly also from the beginning of this year, a lot of other pressing issues on his desk, I'm sure. The President was not willing to sign the bill because he cited constitutional concerns, some of which are quite technical, but some of that are also repeating some of the concerns previously voiced by rights holders. There's the daughter that I mentioned. I told you she's going to at some point make herself heard. So what we have now, it was introduced, it went through Parliament, it went for presidential signature, but it's now being back at Parliament, and in fact it is next week that Parliament will deliberate again. From my assessment, this is a decent enough bill in many ways, and it's better to have that than continue having for the foreseeable future a 1978 piece of legislation. It's also some of the things that people think need still fixing. Regardless of whether they really do, this is not something that cannot be done once the bill is there. So I found that a step backwards, but others are quite joyful about the fact that we haven't proceeded any further than we have so far. In a nutshell, nice thing is it would actually finally propose like something on how to deal with orphan works. This is complicated, as I said here in the proposed section 22A, complicated way, but at least there is a way for getting a license from a body to use works for which one cannot locate or identify the rights holder. I guess that's better than nothing. One is sometimes can also be sometimes surprised that what sounds like a pretty bureaucratic process actually in practice then pans out to be a relatively smooth sailing. So here I think many would have liked to see an orphan work provision to be included. Parallel importation, for those who know what that is, it's basically the question as to whether you can actually import into South Africa copyrighted material from overseas that is legally sold overseas. So if you make that a little bit more practical, if a textbook cost say 600 Rand in South Africa, but you know that the same textbook more or less, that there is an Indian version also in English of that retails in India legally for 300. The question is, can you not bulk import from India these cheaper textbooks, which would create competition to start off with. This would now be expressly allowed, whereas the legal situation previously was a little bit uncertain. And I guess that is the kind of key area that I kind of also here highlighted in red for the exceptions and limitations. What is proposed is to put a fair use, similar to provision into our law, similar to what the United States and a handful or more countries have. Rather flexible, broad enabling provisions for using copyrighted material without the permission, but under consideration of a number of factors to protect the rights holder. And that, in addition to the fair use provision, there are specific exceptions and limitations for educational and academic activities and for libraries, archives, museums, and galleries. And I'm not going to read this out, obviously. I highlighted a couple of things that I know a lot of people are having difficulties with currently. So the questions around creation and dissemination of course packs, for example, is now being dealt with. This, what I have underlined here in 12D number 3 and 4 and 5, I guess, is what upsets some, because it could be read as an enabling provision for copying entire textbooks, which obviously is something that publishers are highly concerned about. But if you actually read the provision closely, it's rather narrow. In fact, the proposed provision says that by default it should not be allowed to do this. It may only be done in certain circumstances, as you can see in 4, and here it says, I have to look onto the bigger screen, where a textbook is out of print, where the owner of the right cannot be found, where authorized copies of the same edition of the textbooks are not on sale in the Republic, and so forth. So this doesn't seem to be instances that then would actually harm the publishers a lot. And then 5 adds to this that making such copies shall actually never extend to reproductions for commercial purposes. So I guess that is there is safety built into the system to prevent the harm that is being claimed in the discussions. And then here, this is probably very important for you, many of you. Have a look what you think about it, 19C in the bill, and then make your voices heard, I guess, in terms of whether you actually think this would make you, your work as practitioners in the field clearer, easier, or not. The opportunity really is only now, because this bill now either sees the light of day soon, or it will be scrapped and we have to start from scratch, essentially. And that means that we will not see revisions of the Copyright Act for many years to come. If I may finish up here with a couple of questions that were actually posed at me from the outset, and just to give you my answers or actually show you that while I was talking here so much over the last hour and 10 minutes or so, is that that I've actually answered many of these questions. So the one was when are items considered to be in the public domain in South Africa, and what can we do with these items? So we talked about that. As curators, are we allowed to digitize materials when we are uncertain as to who the copyright owner is or was, especially in relation to archival material? We spoke about that too. The general answer will be no. Photos and manuscripts are often distributed on social media sites, especially historical and genealogical sites. Can I, without permission, download these and add these to my digital collections? Again, the answer I provided you with was no, unless social media terms of services allow this. So there might be, you might actually, as an uploader of these kind of materials, agree to terms and conditions of the social media website that actually allow others to use your material in certain ways. But normally it will not extend to the kind of users that that are contained in this question. It will rather refer to users that are related in one way or the other to reposting, liking, and whatnot. So within the confines of the social media kind of activity. What, if any, are the exceptions to the South African Copyright Act, for example, fair use? So again, the question already indicates that there is an assumption that we have fair use, even though we don't. We spoke about that too. And then here, the last question on this slide, how hypothetically will the proposed copyright amendment will impact on our service and our ability to copy and distribute copyrighted materials for academic purposes? Spoke about that, although briefly. The proposed bill, in my opinion, would significantly increase the abilities to copy and distribute materials. That's why they are being opposed so much, because this is obviously not something that those who are currently in control of these items like much. And then the other three questions that were posed are a little bit more difficult to answer, I have to admit, for at least two of these. Can we claim copyright to materials in our collections if individuals or entities have deposited them? We spoke about that too. I think not automatically, but you could add this to your collections terms of services, although you probably shouldn't. A license to use is enough. So what I mean with that is, what you could do is you could say in your terms of service for your platform, by uploading material to our website, you assign the copyright over to us. Then you can obviously do whatever you want to do. You own the copyright. Sounds perhaps intriguing, but I promise you will get a big backlash, because the grab of copyright, unnecessary grab of copyright rights, is something that increasing amount of people takes offense with. You as someone who runs a platform, a repository, or what, you do not need the copyright in these works. So you shouldn't also really ask for it. For doing your business, for doing what you want to do with that, you need a license from the rights holder to do certain things. And that really depends on a case-to-case basis. You need to analyze, what do I need to do with these works to do what I want to do? And then you put this into the terms of services in terms of a license, rather than asking full on for copyright ownership. What rights do we have as the entities that digitize materials? Do we own the digital copies? Can we charge fees for reproduction of published works? That is also a question that came up here in the chat. There's no clear answer to that. I think a compilation of works can enjoy a separate standalone protection as a compilation, as a published edition. But it is, after all, still just a copy of the original work. So the question really will be, is that original, as a requirement for copyright protection to come into being in the first place. So yeah, this is really all a question about originality. Rather than relying on copyright here, the contractual and DRM route seems to be preferable from the little bit of research that I have done. So you should rather employ perhaps digital rights management systems to control, if you wish, the use of such materials. But this again might lead actually to a problematic lockup of what otherwise would be public domain works. And lastly, what should we be asking from depositors when accepting collections, and how do we ensure that our deposit agreements are legally correct? My answer would be, well, you need probably the help of a legal professional. maybe from the legal department, if your institution has one, or the organization that you work for. Again, you should ask for all the permissions needed to do what you want and need to do. And again, that requires you to ask these questions. What do I really need to do? Sure. So that was a run through. I knew from the outset that 90 minutes is going to be a tough call. I spoke for a long time into our Q&A session. I hope that as we went along, I actually answered a couple of questions, and also the main questions that were sent around in the invite I also kind of started to address. I hope that you could still hear me. It became a little bit more quiet as far as chat is concerned in the chat box, but I can see still Reynard, and perhaps I hand over to you to kind of to lead the last 5 or 10 or so minutes. I'm happy to stay on longer, but I'm not sure what the confines of the others are. Thank you very much for your time. And please, here's my Twitter handle and email address. If you have questions, get in touch, follow me on Twitter. It was a pleasure to do this. Thank you very much.
Tobias, thank you so much. I think you've answered so many questions that we have, but I realized while looking at some of the questions that came through that maybe we need to as a sector, we need to also have an FAQ someplace where these issues are addressed, because I do not think they're sufficiently addressed in any of our curricula at this stage. I'm not sure about the archival sciences, but definitely not in the library science sector. I think we are fairly, and I know this might sound terribly rude, but I think we in general are fairly ignorant of some of the aspects of the legal environment that frames our sector. And this is immediately the reason why we have the session today, is to start addressing those issues. And I think there's a lot more we can do in terms of the FAQs, that we can sort of create case scenarios that we can better explain those things. So my suggestion, and I'm going to put up my email address here, is for people who attended this to send me questions, and that we can have an FAQ set up, if you don't mind, between yourself, Douglas, Paul, Denise, be able to address those questions sufficiently. But I think what is critical at this point in time is that we support the amendment bill. I know from Denise's side, I don't know whether she wants to say anything about this, but we have engaged with Denise, and a letter from the ASA side will go out. I've seen letters from various entities go to the presidential office, or to the Speaker of Parliament at least, requesting these, or the bill to be signed, the amendment bill. But we also know that it's not about legality, it's not about economic and politics in the end. But we have to do our best to push this for as much as we can. Any other questions we would like to launch? There's a lot of thank yous, and also for arranging this, but it's not about me, it's about you being absolutely fantastic in relaying this critical message to us. It doesn't seem to be any more questions coming through. If that is the case, there's from Janelle to everyone, thank you. The next session will most probably be in about 2 or 3 weeks' time with Paul West, looking at Creative Commons. And I think from a librarian's perspective, it's critical that we work within, especially when it comes to open science, open scholarship, that we start looking at Creative Commons licenses, because I mean, the Creative Commons license is not opposing copyright. In fact, it's actually asserting its use in many ways, but it's opening us up much better for how do we go about using it correctly. And I think that's what I really like about it. But it impacts on a number of our areas, including, for instance, our metadata creation, including, for instance, how to, our open education resources. So there's many things that we can do as librarians in our various entities. But Tobias, I'm sure that we're going to still, if you don't mind, us sending a lot of questions through to you, but I will collate them and I will send them through, and we can work together with the other groups on this. There's specifically also, I want Douglas Scott from Wikimedia South Africa to also address us at one stage, talking about specifically Panorama and what has been done in terms of how does the copyright law impact on the Wikimedia Foundation projects. And then Denise, I would love to hear from your side as well about amendments, explaining in detail what those amendments actually, what are the implications of the amendments that's requested to librarians, because it does actually impact on every aspect of our work. And I'm not always sure whether we work in a legal framework, whether we stick to the legal framework. But that's something that's open for debate. All right, it doesn't seem like there's any other questions. Anybody else want to say something?
I just, if I may, Wayne,
just unmute yourself.
I just feel that I brushed over Sanjin's question earlier, and I was actually looking at it now again. It is a more complex question that we might not be able to address fully here. I think my quick answer, if he is still around, is that it is problematic even if music is being played in the background. To start off with, this is one of the answers to this. And it's also, there's added complexity because there is, in addition to copyright law, there is also a framework called performance protection, and I think your question actually touches on that issue of whether the rights of performers could be infringed. And then the last layer to your question, as far as I can see it here, is the question as to who owns a video of, in this case, rehearsal performances, because there's a lot of people involved. I think from a copyright perspective, this is probably the easiest question to answer, because I think the Copyright Act even currently is quite clear in terms of who owns copyright in the different types of works. So it is in all likelihood from the different stakeholders that you mentioned here, it will be the director well, it depends of whoever takes the video, or if the video is recorded of something that someone else directs, it's probably the person who records that video who owns copyright, but it may still infringe performers' rights on the side. So it's quite a multi-layered question, and I'm happy to have a follow-up one-on-one discussion on that, but I just didn't want to just brush over this. Thank you.
Thank you, Tobias. Just two things. One, Denise has just indicated in the chat that she, and I've gone to that LibGuide many times. Denise Nicholson at WITS. Just Google her and you'll see her LibGuide. It contains a wealth of information pertaining to the copyright laws of South Africa. Also, if you Google her name, you'll see that she was one of the people who often debate on various platforms regarding how the copyright law impacts us. And then, Tobias, I just have to ask, if I understood you correctly just now, Liasa owns this recording, but not the presentation that you rendered in the recording. Am I right?
Sorry, I have to unmute myself. I know we are at the end of this, but I just can't help myself just sharing my screen again for a second, if I may, because what you will see is that at the last slide, that I actually do attach a Creative Commons license to my own presentation. So what that effectively means is, no, I do own the presentation, but you're more than welcome to distribute it and use it in line with the license that I've attached to it.
Yeah.
That's kind of walking the
talk.
talk.
Thank you. I was just trying to make a point on the complexity of what we're working with, because one entity is recording, one is presenting, etc. And we need to respect those different aspects of the creation process and think in terms of what we do every day. From Tobias, thanks all. Well, in that case, I think this is the end of the session. Please be lookout for more information. And Tobias, I'll also include you in the invites going forward with Paul, Douglas, Denise, etc. That I still haven't spoken to some of them yet. So it might come as a surprise now. But to have the various role players in the country constantly talking to us as a sector, I think it's critical that we hear it from different people and different sides of the same coin. So we would love that. But to Tobias, thank you very much for everything. To the participants, you're great, asking the right questions. And Anna Marie said there might be a problem with the recording, but we'll see what we can do, and hopefully we can get a recording out to everyone and also share beyond this group. I know there's been lots of issues. While you were talking, our electricity went off because of load shedding, and I had to reconnect, to change my PC again, etc. So it seems quite easy, but it's not. There's a lot of things happening in the background. But again, Tobias, thank you so much for your time. We know it's precious time. Can I just ask, are you a minimalist? I only see a chair to back.
As far as my Zoom backgrounds are concerned, yes.
Ah, all right. All right. No, thank you so much, and thank you to great participants. And yeah, keep a watch out. There's a lot of things happening on the LIASA website and a lot of planned events, and we hope to see you all again. Thank you. Bye.
Bye all.